Have you ever thought about this? The government decides to create one single ID card for every single citizen. All your data, all linked up in one place, all for the sake of efficiency. I mean, it sounds convenient, doesn't it? But what if it also created a permanent, unerasable record of your entire life? Well, that's the heart of the conflict in the landmark case of Ople v. Torres, a battle that really forced a nation to ask, what is the true price of privacy?
You know, to really get the weight of this case, you just have to look at the words the Supreme Court itself chose to highlight. This was never just about data or technology. It's about what Justice Brandeis so famously called the right to be let alone, which he saw as the most fundamental right of them all. And that simple, powerful idea, that's the battleground for this entire case.
All right, so here's how we're going to unpack this whole showdown. First, we'll dive into the government's big plan for a national ID. Then, we'll look at the two major constitutional arguments that were brought against it. We're going to dissect the court's thinking on presidential power versus personal privacy, which all leads up to the final verdict and the powerful legal standard it set for all of us.
So, what exactly kicked off this constitutional firestorm? Well, it wasn't a law passed by Congress. It was a single directive that came straight out of the president's office, Administrative Order Number 308.
So let's go back to 1996. President Fidel Ramos comes up with what on the surface seems like a pretty modern solution to an old problem. The idea behind AO 308 was pretty simple. Let's streamline the bureaucracy. Everyone would get a single population reference number, or PRN, and that number would link up all your government records. It promised to make things more efficient and, of course, crack down on fraud. But how they planned to do it? Well, that's what raised some serious alarms.
Now, a plan this ambitious wasn't just going to fly under the radar. A challenge was brought almost immediately by a major public figure, Senator Blas Ople. And he didn't mess around with the lower courts. He took this fight straight to the Supreme Court, arguing this was a matter of urgent national importance.
Senator Ople's challenge really stood on two constitutional pillars. The first was a question of power. Can the president just create a massive system like this on his own, or is that a job that only Congress can do? And the second was a question of rights. Does this system, just by its very design, cross a sacred line and violate every citizen's right to privacy?
Okay, let's dig into that first issue, this whole idea of separation of powers. See, the Constitution draws some pretty clear lines for each branch of government. So the question here was, with AO 308, had the president kind of swerved out of his lane and into Congress's territory?
The Constitution is really clear on this point. Congress makes the laws, the president enforces the laws. The whole case came down to this one question. Was AO 308 simply about enforcing a law that already existed, or was it creating a completely new one out of thin air?
And the court's answer on this was decisive. They basically said that IO 308 went way beyond simple administration. By creating a whole new national system that fundamentally changes the relationship between a citizen and the state, it was a clear act of lawmaking. And that power, the court said, belongs to Congress and only Congress.
But here's the thing. Even if Congress had passed this law, there was a second, much deeper problem: the right to privacy itself. So the court then turned its attention to the actual technology behind this ID system to figure out if it was a clear and present danger to this fundamental right. The engine driving this whole new system was something called biometrics, which is just the science of using your own unique physical traits as your identifier. And we're not just talking about a photo on a card here. We're talking about technology that could identify you based on the very building blocks of who you are.
And what really seemed to worry the court was just how broad this technology could be. See, AO 308 was super vague. It didn't actually specify which biometrics would be collected. It basically opened the door to everything from fingerprints and retinal scans to some pretty futuristic stuff, like an artificial nose analyzing your skin, or a thermogram mapping your face's heat signature. It wasn't a slippery slope, it was more like a cliff. By linking every single government interaction to one number, the system would create this giant, centralized treasure trove of personal data. The court called this a covert invitation to misuse, a temptation, they warned, that some people in power might find way too great to resist.
And that leads to maybe the court's most chilling warning of all: the power to generate a cradle-to-grave dossier. Just imagine that. Every interaction you have with the government, from your birth certificate to your tax returns, all the way to your death certificate, all compiled into one single, permanent digital file. The court didn't see this as just an inconvenience. They called it one of the most graphic threats of the computer age. So, with the president's power in question and this massive threat to privacy laid out on the table, how did the Supreme Court finally rule on AO 308?
The verdict was swift, and it was unambiguous.
The court declared Administrative Order Number 308 null and void. It was struck down, plain and simple, for being unconstitutional.
So the court's reasoning really boiled down to two fatal flaws. First, the president overstepped his authority. He tried to make a law which he can't do. And second, the order was just so dangerously broad and vague. I mean, it had no specific safeguards to protect people's data, that it was a clear violation of the right to privacy right on its face.
But this ruling was about so much more than just striking down one administrative order. It was really about reinforcing a powerful legal shield for one of our most essential rights.
The case of Ople v. Torres really cemented a critical principle. The right to privacy is not a luxury. It's not a secondary concern. It is a fundamental right woven right into the fabric of the Constitution, and it deserves the highest level of protection.
And because privacy is a fundamental right, any attempt by the government to limit it has to pass the highest legal test there is, something called strict scrutiny. This puts the burden completely on the government. It's not enough for them to say a law is useful. They have to prove a compelling reason for it. And they have to show that their plan is the least intrusive way possible to get their goal. And AO 308, it didn't even come close to passing that test. And all of this leaves us with the central question of our time, one that's arguably even more urgent today than it was back then. In an age of AI, social media, and big data, the challenge from Ople v. Torres is louder than ever. How do we balance that constant push for security and efficiency with our fundamental right to simply be let alone?